Hi, everyone, and welcome to our HDFC Training Series, the first of what we hope to be many presentations about topics of interest and concern to our HDFC clients and prospective clients. Today, my colleagues Megan and Jonathan will be presenting on two different topics that we're tying together because they've created legal uncertainty in the midst of the COVID-19 pandemic. So Megan Boland is a graduate of Brooklyn Law School, and she's from our litigation team. She's going to be discussing some COVID impacts on landlord-tenant practice. And my colleague Jonathan Wong, also a Brooklyn Law graduate, is going to present on some of the COVID impacts on transactional HDFC buying and selling, and mostly in our role as the transfer agent for buildings. So any questions that are provoked by something that somebody has said in their presentation, we'll have time at the end for a Q&A. And you can also use, I think there's a feature at the bottom, there's a Q&A feature where you could record your questions and we can pick them up and answer them as we see fit. So I think, take it away, Megan.
Thank you, Rachel. So as Rachel mentioned, I deal primarily with litigation and deal a lot with landlord-tenant and in our HDFC practice. So it's likely that some of you have worked with me in the past. In working with our HDFC clients over the past 8 months, we've noticed that a lot of them are having trouble dealing with shareholders who have fallen behind on their maintenance obligations. And so here we're going to discuss some creative solutions for board members to respond given the unique challenges posed by the COVID-19 crisis. And so first, just to make sure we're all operating from the same information level, I'm just going to start with a brief landlord-tenant law overview. And so as many of you are aware, the relationship between a co-op and a shareholder is that of a landlord-tenant. And in New York City, landlord-tenant disputes are primarily adjudicated in the civil courts of the city of New York. And they are adjudicated through what are called summary proceedings, which are a type of expedited hearing that typically are cheaper and quicker than Supreme Court proceedings. And summary proceedings typically fall into two categories. The first is a non-payment proceeding, the second being a holdover proceeding. So first, non-payment proceedings, as their name implies, are cases where the primary issue before the court is whether the shareholder owes outstanding maintenance. And so if at any time the shareholder pays the outstanding maintenance, the case is at an end and the matter is resolved. The shareholder has, from the day the notice is sent until the day the marshal is knocking on their door to satisfy the arrears. So there are many opportunities for the shareholder to cure their default. And this is the preferred method or type of proceeding for HDFCs, where the primary concern is collecting maintenance. And before you can go to court, you need to send shareholders 2 notices, the first of which is new under the HSTPA, and it's a 5-day late rent notice. It's a pretty brief boilerplate document that just lets the shareholder know that they are behind on maintenance and that this is their current balance, and please reach out to the landlord to either discuss or to make a payment. The second notice is the 14-day rent demand, which has been in place for some time. It is a slightly more technical document. So while some of our clients do prepare the 5-day late rent notice on their own, we definitely encourage you to have an attorney assist you with both of them. The second proceeding is a holdover proceeding. This is a broader category where effectively the issue is that the landlord is alleging that some conduct on the part of the shareholder is in breach of his or her proprietary lease and is such that the landlord is now entitled to terminate the lease. They are not easily cured. And so it is a somewhat higher burden for the landlord. But if your end goal is to recover the unit, not just seeking to have arrears paid, this is often a preferable tool for HDFCs. And so grounds for termination, as you're likely aware, are non-primary residence, illegal subletting, nuisance or objectionable conduct, illegal use or alteration of the premises. But for our purposes, the one that we're going to focus on is chronic non-payment. So in a chronic non-payment, this is again a holdover proceeding, but similar to a non-payment proceeding, the issue before the court is whether a shareholder is behind on maintenance. But this is really for those instances where you have a shareholder who is constantly behind on rent. You've brought him or her to court on multiple occasions before this, and the court orders them to pay. And then within weeks or months of resolving that non-payment proceeding, the shareholder is again falling behind, and you again have to bring them to court. And this has developed a pattern with the shareholder, and you're at a point where you no longer are just concerned about the maintenance, you want to terminate the tenancy. So the court is going to look and determine if the shareholder has chronically and unjustifiably refused to pay maintenance. And you can demonstrate this by having a history of prior non-payment proceedings pending against or have been brought by against the shareholder. And all of those prior non-payment proceedings need to have been successful, which means they need to result in the shareholder having paid all or substantially all of the maintenance that you sought in that non-payment proceeding. If the shareholder was alleging that they were withholding maintenance for some reason, like conditions in the building, that can cancel out one of your non-payment proceedings. So you really need to have a clear chain of prior non-payment cases. There's no magic number, but I would say you need at least 3. And then after having brought that shareholder to court successfully under a non-payment proceeding, you can bring a holdover proceeding on the grounds of chronic non-payment to not just collect the maintenance, but to ultimately terminate the tenancy, regardless of whether the shareholder ultimately pays the outstanding maintenance. And so in addition to shareholders, our HDFC clients have also been experiencing some difficulties with collecting maintenance from estates or after a shareholder has passed away. You have multiple avenues here, and it depends on the unique circumstances of that specific unit. So where there is an estate in place, meaning that someone has received letters of administration or has been appointed to act as the individual charged with managing the decedent's affairs, you can sue the estate directly in housing court through a non-payment proceeding. And where there is no administrator and no estate has been formed yet, but there is a readily identifiable survivor, whether that is a surviving spouse, surviving children, or other distributee that you can locate. You can also bring a non-payment proceeding against the surviving relatives once 3 or more months of maintenance have accrued. in instances where there is no administrator in place, no easily identifiable relatives, unfortunately, then you do need to go to surrogates court and ask surrogates court to petition. You do need to petition surrogates court to have someone appointed to serve as administrator. And so it's only then once an administrator is appointed that you can move through surrogates court as a creditor of the estate and seek to recover the outstanding maintenance from the estate. And so everything that we've talked about thus far is, you know, from the pre-pandemic playbook. This is how you would operate when the courts were open and full and functioning, and marshals were out serving warrants, and we had no moratoria to be concerned with. And so now we're just going to discuss the two moratorium that impact New York State. The first is the various New York State executive orders and the Tenant Safe Harbor Act. And the second is the federal moratorium, which was issued by the CDC in September. But I don't want to waste too much time talking about the specifics of either of them, because regardless of these orders issued by the state and federal governments, at the court level, the courts just are not operating really in any meaningful capacity. They were shut down for several months at the beginning of the pandemic. They have slowly reopened over the past couple months and weeks, and are now hearing a limited category of summary proceeding virtually. And those cases are only instances where both parties are represented by counsel. So if there are any cases that were filed before March and had been conferencing as normal, but the shareholder was just pro se, those cases have been paused effectively for the past 8 months. They have not been conferenced. There are no new dates. They're in limbo. The only cases that we are conferencing are, again, ones where an attorney is involved. And so there's really a very narrow category of pre-existing cases that are moving forward, and they are moving forward slowly. The courts are not issuing any judgments of possession. And so the only resolution that we're seeing is resolution between the parties, either by entering into some kind of payment plan, or the courts giving a shareholder time to enter, or seek government assistance and pay their balance that way. And so we are going to talk about the moratorium, but I just want to set expectations that regardless of, any kind of carve outs that they may contain, realistically, we're not going to be able to run to court and get any kind of judgment of possession anytime soon. On that note, the New York moratorium was announced in late March, and the Tenant Safe Harbor Act was announced in June. Again, residential and commercial evictions are stayed through the end of the year. In theory, the current state moratorium will expire on January 1st, but it's likely that they will be renewed or extended in some form. And so in addition to prohibiting evictions, they also prohibit landlords from collecting late charges. And if a tenant can demonstrate that or can allege that he or she is facing financial hardship, they can ask that any security being held by the landlord be applied to their current balance, and then negotiate with the landlord to replenish the security over time. And just as landlords cannot receive or enforce any new orders of possession, any orders of possession that were issued prior to the commencement of the pandemic but were unable to be executed before the pandemic, now need to go back to court and seek additional court approval to effectuate those judgments. So again, there is a significant backlog in the courts, and there is also a significant backlog with the marshals. So it's going to be, months before logistically you can forcibly remove a tenant from the premises. And the CDC moratorium, again, this is the federal moratorium. It is narrower than the state moratorium, so it has limited applicability in New York State because most tenants or shareholders won't be bothered to avail themselves of this protection because it requires that a shareholder make a sworn statement affirming these 7 items that are listed in full here. But essentially, they need to affirm that they have made best efforts to obtain any and all government assistance that is available to them, that they have been financially impacted as a result of the pandemic, either due to loss of wages or due to significant health expenses, that they have been making best efforts to pay what maintenance they are able to based on their other financial considerations. And they'd also are at risk of homelessness. So in order to qualify for these protections, they need to have really exhausted any and all government programs and prove that they have exhausted those programs, and for whatever reason were not able to qualify. And they need to be making efforts to pay whatever maintenance they can. So they need to be making partial payments, and they need to kind of eventually prove that they were unable to make more significant payments. Again, because this has limited applicability in New York, logistically, we just don't expect to see many shareholders submitting these statements. So it remains to be seen how closely the courts are going to look at these sworn statements and how much they're really going to press tenants to prove that all of these statements are true. But again, for our purposes, I don't think it has much pragmatic impact. And so the main takeaways should be that neither moratoria waive any shareholders' rent obligations. It is merely a stay on a landlord's ability to enforce an eviction. Shareholders are all fully liable for any past and future rent. There is no rent forgiveness as a result of the moratorium. And similarly, landlords are not prohibited from attempting to collect rent. It just means that beyond the landlord's private collection efforts, if those fail, the courts are not going to step in and help them. And as I mentioned previously, both are set to expire at the end of the year. But I think given the governor's history of extending the executive orders, the incoming Democratic administration at the federal level, and the current increase in reported cases, we should all expect that it will be some time before the moratoriums are lifted. So on that note, we have been working with HDFCs to find new ways of collecting rent and encouraging shareholders to pay maintenance. And the first sounds extremely obvious, but I would say with the vast majority of our HDFC clients, we encounter this problem in some degree or another. And that is just maintaining good records. And by that, we mean making sure that you have a copy of the proprietary lease and the stock certificate for absolutely every shareholder. If you do not have a copy, now is the time to reach out to the shareholder and see if they have a copy and that they're willing to share. And if neither of you have a copy, you should reach out to counsel about what workarounds and substitutes we can have, if we can replace them, or if there's some other document that we can prepare for you to stand in for them. The other document that we need is a zero balance rent ledger, which is a rent ledger that dates back to the last time the shareholder was current on his or her rent. So for example, if a shareholder was last at a zero balance and had last paid up on maintenance back in 2018, then we need a rent ledger that goes back to 2018. And with HDFCs in particular, we see a lot of instances where shareholders have been making partial payments for years, sometimes longer. And it's been a considerable amount of time since that shareholder was caught up. But because they've been making partial payments, the board didn't take immediate action and allowed the situation to sit for a while. So there are circumstances where it may be difficult for the board to locate a zero balance ledger. So now is definitely a time to take stock of your records. If you don't have any of these items, you should definitely reach out to us about what we can do to locate or replace them, and help you institute policies moving forward to make sure that when the moratorium are lifted, you have all the documents you need to prepare for a summary proceeding. And similarly, we advise that boards have a meeting where they discuss implementing a current policy to govern their enforcement of maintenance payments. All too frequently, we see HDFCs who stall in sending notices until the situation is critical and we're at a point where a shareholder, owes significant arrears like 10,000 or more, and then for the HDFC, it's at a critical point, but the courts don't function even in the best of times as quickly as the building then needs them to, and the building's financial well-being can be at risk. So we know for HDFCs in particular, the enforcement of maintenance obligations can be uncomfortable. HDFCs more than any other landlord-tenant relationship often function as kind of a pseudo community. It's likely that the board is neighbors, friends, or even family with some of the shareholders. So implementing a consistent enforcement policy can be a great way to prevent the board from failing to act in a timely manner. So, for example, some of our clients have a policy where every month automatically any shareholder who failed to make a timely payment is getting at least that first 5-day notice. We have other clients who take a somewhat more relaxed approach, and they've set a monthly threshold. So if a shareholder, say, falls 3 or more months behind on rent, that shareholder is getting a notice automatically. Or they set a monetary threshold. So if a shareholder falls, say, $3,000 behind on maintenance, anyone $3,000 or more is getting a notice. So that way, it depersonalizes it a little bit. It can make it easier for boards to uphold their fiduciary duties to the other shareholders. And so on that note, we encourage you to consider starting to send predicate notices now. If we, take an optimistic view and assume that the moratorium will expire at the end of the year, we're already in mid-November. By the time you get your documents together and get your attorney everything they need and they prepare and serve the notices, we will be close to January. So it sounds far off, but this is closer than you think. So if after you've had a chance to evaluate your records and develop a policy, you determine that any shareholders qualify to receive notices, now is the time to start sending them. And similarly, if you don't want to take as an aggressive as an approach as sending notices immediately or as frequently as monthly, you can still reach out to shareholders on a more informal basis. Now is definitely a great time to check in with all your shareholders and see what his or her individual circumstances may be. If you have a shareholder who's fallen behind over the past several months, and you're able to communicate with her and it turns out she's not employed, but is starting a job in the next couple weeks and is able to work with you on some kind of buyout or payment plan, that's something that you can have a conversation with them about, and maybe avoid unnecessary litigation costs if there's an end in sight for that shareholder. And then similarly, if you are aware of any government programs or subsidies that your shareholders may qualify for, but for whatever reason are not taking advantage of, we do see that where tenants qualify for various programs and for one reason or another just fail to take advantage of them, or are not aware of these programs, or if they are receiving some kind of subsidy and their circumstances have changed, maybe they haven't reached out to the issuing agency and notified them that they are now in a different position and they might qualify for additional aid. So if there are any programs that you're aware of that you can pass along to your shareholders, that's also a great way to engage with them while we wait for the courts. And so on that note, I'm going to pass this over to my colleague, Jonathan, and then if you have any questions, we can address those at the end.
Thanks, Megan. Can you hear me? I'm not on mute, right?
Yeah, I can hear you.
Okay, great. My name is Jonathan, transactional associate at Goldstein Hall. I do a lot of the closings for HDFCs as transfer agent when there is a upcoming closing. And during this presentation, I just wanted to talk about the overview of the closings and transfers during COVID. We'll cover, just as a general overview, the different types of closings first and the considerations, the role of the transfer agent in these closings, remote closings versus in-person closings, as well as preparing for closing and closing costs. So the first type of going to types of closings and considerations. The first type of closing, I would say, is your typical standard closing where you have a selling shareholder who's putting the unit on the market. They may or may not be working with a broker. Typically, we'll also have an attorney who will guide them through the process and prepare the contract of sale. You'll have a purchaser interested in buying. They'll work through the contract and there possibly may be financing. And then this purchaser, once they're further along in the process, they'll be there to seek board approval and whatever other requirements the board will need, whether it be an interview, income verification documents, to provide such an approval. And then the second type of closing would be typically adding or removing a shareholder. When the board receives such a request from a shareholder to add someone, it's usually, or at least I find, to add a family member to the share and lease. Considerations from the board when they receive such a request is the proposed shareholder over the age of 18? Is the unit the primary residence of this individual to be added to the stock and lease? Does the individual meet the income restriction requirements necessary under the corporate documents? Once we get verification of that, as well as board approval to move forward with the transfer, a question for the shareholder becomes, now that there are more than one shareholder on the stock and lease, how will they be consider holding ownership. And you go into, there are different ways to hold ownership. As an example, you could hold as tenants in common. You could hold as joint tenants with the right of survivorship. Solely for married couples, they're tenants by the entirety. If they're doing this for estate planning purposes, I would advise that these shareholders reach out to an estate attorney to advise them if they're doing it for some sort of planning, to really understand how they should be holding ownership based on their goals. And then they would provide the confirmation to the transfer agent so that we can make sure that it's correctly reflected in the ownership documents. The third type of closing would be when a shareholder is being removed from a stock and lease. So in that example, you may have multiple individuals on a stock and lease, 2, 3, or however many there would be. The most important consideration I would say for the board at that time would be making sure that prior to that shareholder being removed, that a lien search be conducted to review and make sure that any of the that whether or not there are any liens against the unit. In the event there are, these would need to be cleared prior to closing. The issue if there is no lien search ordered, or if there are liens on the unit and the closing moves forward, is that it may be very difficult later down the line for these liens to get removed. So you would really want it to be done at this moment in time, especially when the individual who the lien would be against is still present prior to being removed. So we would work with all parties and especially reviewing the lien search to confirm whether or not there are liens and the process moving forward. In addition, for the board consideration, if there's any outstanding maintenance owed, this would also be the time for those shareholders to provide to get up to date for the maintenance owed to the HDFC. And in addition, removing a shareholder would also require board approval. On this slide, I want to talk about the role of the transfer agent. So Goldstein Hall, we represent many HDFCs, and we will act as transfer agent for when there are closings or transfers that need to occur. What that means is that in a co-op closing, you'll have the selling shareholder with their attorney, you'll have the purchasing shareholder with their attorney, and then the transfer agent on behalf of the HDFC is there to facilitate the closing between the two parties. And facilitating the closing means making sure that the stock and lease of the seller is properly voided so that the stock and lease of the purchaser can be properly issued. There are other closing documents that need to be prepared in addition to just the voiding and the issuing of the stock and lease. You have certain assignment documents, you have certain acceptance documents. The new purchaser needs to receive their new stock and lease, that's all, as well as their new stock certificates. These are all documents that or some of these documents are signed by the board, as well as require multiple signatures of board members. The transfer agent prepares those documents to be signed by the parties and then facilitates and coordinates the execution of those documents for the closing. I mentioned before on my previous slide that it's important to get a lien search. The transfer agent will receive the lien search and review the lien search to make sure that when there's the transfer of the shares, that these are being transferred free and clear of any liens. And then I think I already touched on this last point. A transfer agent will coordinate and facilitate the closing between all the parties. That's reaching out to the seller's attorney, the seller, the purchaser's attorney, the purchaser, as well as the board to make sure that everything is in place leading up to that closing date. So in-person versus remote closings. prior to COVID, closings would be that the parties, or you wouldn't have remote closings. Especially for a co-op. For co-op closings would be that the parties would go to the transfer agent's office, Goldstein Hall's office. We'd sit around the conference table. If the purchaser was financing, their bank would also be there. If the seller had outstanding monies owed to a lender, their payoff bank would be there. You'd have the attorneys and then the transfer agent, myself, being there to facilitate, to shuffle around the documents. And it was as easy as making sure that documents were correctly passed around and fully executed. Documents could be notarized at the closing table. We were able to make lots of copies, as well as deal with any issues at the closing table. But with everyone now on, working remotely, or some people working remotely or partially going in person to work, closings have had to evolve, and we now do remote closings. I would say that I listed all of the parties that are typically involved with a closing, whether it be seller's attorney, purchaser's attorney, payoff bank, purchaser's lender. And I find it very helpful right in the beginning, as soon as, let's say, board approval is received, or even prior to that. It's important to actually schedule a conference call or just have a call with all of the parties so that we can go over logistics, discuss the process, who's not comfortable with meeting in person, and what that looks like depending on the considerations of the health and safety of all the parties. I find it incredibly helpful with that conference call, and thankfully, we're able to conduct closings that way. So as soon as board approval is received, I would say that, or the takeaway from that would be, it's important to get that contact information to the transfer agent as soon as possible. Touching on the process and timing. So in general, when we're conducting a remote closing, and I mentioned before that the transfer agent will prepare these documents, or the closing documents, I find that it's around about 3 packages that I'm sending out and then waiting for 3 packages to be received. Of the 3 packages, you have a package to the HDFC to have the documents that are signed by the HDFC for the closing coordinated and executed for that. So it's a FedEx package to the HDFC with a FedEx package back to the transfer agent. The second package is the package to the selling shareholder and their attorney, and then a package back to myself. And then the third package is package to the purchaser and their attorney, and then package back to me. Within the package for the corporation, you'll have the 2 new proprietary leases to be signed by the board. You'll have the stock certificate that also needs to be signed by the board. You'll have the consent of the corporation, a board resolution, maintenance letter, and possibly recognition agreements if the purchaser is financing, all to be received and sent to the building, which I'll touch on later in my slides. Information that Goldstein Hall would need at the start of this process. For the documents to the selling shareholder, you have assignment documents, assignment of the proprietary lease, assignment of the stock certificate. For the documents to the purchasing shareholder, you have the acceptance of the lease, you have the new proprietary leases that need to be signed. And then going to my next bullet point, some of these documents need to be notarized, especially for the documents from the board. The new proprietary leases need to be signed and notarized. The consent of corporation needs to be notarized. Under the governor's executive order since COVID, that has allowed for remote notaries, and Goldstein Hall has the ability to conduct a remote notary, depending on the ability of the board member who's signing the documents to coordinate a notary within their area, or maybe there's a notary within the building. If that's not the case, then as counsel for the HDFC, we can remote notarize your documents, and there's a whole process around that. So that's just something to consider for the documents that need to be notarized. When preparing for closing, I find it very helpful that the information from the HDFC is a few things. So one, a point person at the building who can be the one to facilitate the coordination of the documents. Where is the package of the HDFC's documents for the closing going? Or who can receive them? Do they have the ability to coordinate those documents and get the signatures from the other board members that need to sign, especially the board resolution? The board resolution requires signatures of board members who approve the sale at the meeting. The proprietary lease and stock certificate typically require 2 signatures of the board. On the first signature, you'll have the president or the vice president. And then on the second signature line, you'll have the secretary or treasurer. And who has the corporate seal? Certain documents need to be sealed. You have the proprietary lease, the stock certificate, the recognition agreements that need to be sealed, as well as whether or not a remote notary is needed. And then facilitating that between Goldstein Hall and the point person at the HDFC to make sure that all the documents are properly executed. In addition to that, with especially for timing, if we want to limit the amount of FedExes going back and forth between all the packages, I typically ask that the board member may scan the documents to me so that I can just confirm prior to it being shipped that all the documents are fully executed. It's definitely helpful to do that because sometimes signatures get missed or something might not be properly sealed. So doing that and working with myself or whoever's representing the HDFC as transfer agent prior to closing would be really helpful to make sure that there are no issues leading up to the closing day. Lastly, during in-person closings, I mentioned that everyone's at the closing table. In addition to documents being signed, once everything is fully executed, towards the end of the closing, checks are being passed around. Transfer agent would typically receive the checks for the HDFC. We would make copies and then we would FedEx them to the point person at the HDFC to receive, whether it's the HDFC or the building's managing agent to deposit it so that it can be put into the HDFC's account. During remote closings, when everyone is in different locations, the process has been that we're receiving wire transfers for the fees owed to the HDFC. So typical fees owed to the HDFC, you'll have the flip tax. We'll confirm what that amount should be prior to closing. If there's any outstanding maintenance owed by the seller, we'll also want to receive that. 1 month maintenance from the purchaser. The month prior to or after the closing, we'll receive from the purchaser so that they can not have to worry about that for the month after their closing. If there's a move-in or move-out deposit, we'll also receive that. So typically, though, in this remote closing environment, these wire transfers would be sent to Goldstein Hall, and then so that we can confirm closing right away on behalf of the HDFC, and then send the wire to the HDFC with a breakdown of all of the funds, or one wire to the HDFC with a breakdown of the allocation of why this one lump sum is what it is. This portion is the flip tax, this portion is the outstanding maintenance, this portion is the purchaser's maintenance. So information from the point person to Goldstein Hall, please provide your wiring instructions, especially if a remote closing is occurring. On this slide, I wanted to talk about preparing for closing and closing costs. First being an attorney contact information. I mentioned before that I find, especially when we're conducting remote closings, that reaching out to the attorneys or having a conference call with them as soon as possible is very helpful to making sure that this process runs smoothly. Like I said, I find that with the health and safety, or considering the health and safety of all the parties, that more often than not, we're not having closing in person. So coordinating those logistics of remote closing as soon as possible is very important. And whether it be the second type of closing or the third type of closing, where a shareholder is adding a family member or removing a shareholder, providing their contact information to facilitate the closing, where they need to sign documents and then I have to receive them as transfer agent and then issuing them the new stock and lease. Where am I sending that? So provide their contact information as well will be very helpful. Seller side, we need to confirm that they have the original stock and lease. If they do not, we'll ask them to confirm, as well as sign an affidavit, a lost stock and lease affidavit. So receiving that which needs to be prepared and signed and notarized. So we ask for that confirmation as soon as possible. Coordinate closing documents and notary. Again, typical fees owed to the HDFC. You have maintenance and flip tax, and if there's any other fees owed to the board at the closing, we make sure to confirm that with the board member or the board, the point person, the managing agent, so that the amounts owed to the HDFC do get paid at closing. Other closing costs to consider: when there is a transfer for consideration, you'll have there may be transfer taxes owed, there will be transfer taxes owed. When it's zero consideration, the transfer tax forms will be filed, but they shouldn't trigger any transfer tax, as well as any of the professional fees owed by the parties, including the fee owed to the transfer agent, as well as any review of documents or the purchaser and seller's attorney. So that's been the closing process under COVID. Different types of closings, as well as the process. I think the takeaway or important to consider is that while closings, when they were in person, were easy enough to finish day of, when you're doing a remote closing, the process does take a little bit longer. The considerations for timing will definitely depend on how soon, based on those three packages, that those documents can get back to the transfer agent. When a board member is coordinating the signatures of the board for those documents, the issue also may be that whether or not that certain board member or some board members are in the building or available, and then sending the package to FedEx. So I would say that when the board does receive a request for one of the closings that I mentioned, please reach out to us as soon as possible, and we can start this process so that closings can occur expeditiously and as soon as possible. Thank you.
Thank you, Jonathan and Megan. First, before we open it up to more questions, Cynthia Nelson has a question. I think this is best answered by Jonathan. Cynthia asks whether contractual agreements are legal if they're between the seller and an applicant prior to the board's approval or knowledge. So that's a great question. Jonathan, do you want to weigh in on that?
Yeah, of course. Yes, the answer is yes. So in the form contract of sale, there's a provision in there that states that this contract is contingent upon receipt of board approval. So in the event the purchaser doesn't receive board approval, then the contract gets terminated. So, so a selling shareholder could enter into a contract with a prospective purchaser. The purchaser will work through the process of obtaining financing. If they are financing, they'll work through the process of filling out the board application, as well as providing any of the information required by the board, in addition to scheduling an interview, if the board requires. In the event the board doesn't approve, the contract contemplates what occurs.
That's great. Thank you, Jonathan. Also, I received a message before our presentation started tonight, and it was a question about whether asbestos removal is mandatory and who is financially responsible. So even though we didn't actually talk about this, and maybe it would be a topic for a future HDFC training, I'm happy to answer this question. And my first part of the answer is it would depend on the terms of the HDFC's proprietary lease. But generally, a co-op corporation is responsible for structural issues like the floor slabs, subfloors, things, supportive walls, stuff like that. And the shareholder is responsible for floor surfaces, decorative aspects, wall tiles that might have contained asbestos. So if, assuming the HDFC had what are considered pretty standard policies about who's responsible for what, the shareholder would be responsible for replacing floor tiles and surface materials. But if it's behind the walls, like insulation, or if it's something like the roof of the building or something similar, then that would likely be the corporation's responsibility. So it would really depend on whether it's a surface part of the building, or if it's behind the wall or a structural part of the building. And I also, while we're talking about asbestos, I just wanted to let people know that, first of all, it's really common in New York City. And the second thing is that New York has some pretty strict rules about how asbestos is handled. So local law 76 and local law 85 require any renovation job that requires a DOB approval, the New York City Department of Buildings approval, would also then require an asbestos survey by a licensed certified inspector. So some of our clients have been in the midst of a capital improvement or other type of major renovation, and the asbestos during that process was uncovered unexpectedly during that inspection. So something to keep in mind, if you're working with Goldstein Hall on a policy, like a renovation policy for your residents, some of our clients have chosen to also maybe clarify things like this, like who specifically would be responsible if the test showed asbestos inside the unit versus in the hallway versus on the roof, and people just choose to really clarify it. So that's some food for thought. I think I'm seeing another question pop up. Okay, so this is a question from Alfred to, I think, Megan would probably be a good person to answer this. We received a favorable judgment against a shareholder in a holdover proceeding before COVID, but the judge allowed the shareholder to stay while assigning a guardian to manage the rents. Does it mean the co-op now owns the shares and they become a tenant? So I don't know. There's a lot of legal issues in this question. I don't know if you want to sort of break it apart, Megan.
Yeah, I think it sounds like this is kind of a unique situation, so it might make sense to have a direct conversation offline, depending on what the contents of the order said. But because there's a few ways that this could have shaken out. It's possible that due to COVID, the judge was just kind of staying the judgment because they didn't want to evict someone who may or may not be at risk of homelessness during a pandemic, while also requiring that the occupant pay use and occupancy, or, you know, if there is a capacity issue, that can get a little more complicated. So I think it would, there's a lot of individual circumstances here that could have some major consequences for what the outcome was. The judge's order would definitely help clear things up. So if you want to reach out to me directly, and we can set up a time to discuss the specifics separately, that would probably be more useful.
Thank you, Megan. And that reminds me, all of the material that we've covered tonight and the questions and the answers and everything are for information only. We're not necessarily providing legal advice that you can rely on. It's just for your information and to get the conversation started. But if you have a particular legal need, you can just use the contact information that's on the slide right now. Does anyone else have any questions or comments about anything we covered today? Oh, somebody raised their hand. See. Trying to figure out how we can see. Can the individual who has the comment or question type it in the Q&A or the chat feature at the bottom of the screen? I think it's Galit. If you, I can't see you, so if you can type your, oh, I'm sorry. Okay, it was an error, no worries. If anyone else has any questions or comments. Okay, well, we are ending almost exactly on schedule as we planned. And again, if you think of something after we end today's presentation, don't hesitate to contact one of us, and we'd be happy to talk more to any of you. So have a good evening and stay safe.